topics for constitution and polity. Now we will be today, as we have got some technical difficulties, we are starting at 8:30. We will try to complete 50 most important questions from the governance, constitution and polity. The soft copy of these questions and the topics have been sent in our groups. Those who are listening live as well as those who will be listening after the recorded videos in the YouTube, you can see first the pattern. Let me explain you the pattern by which we will go. We will deal first. I'll explain you all the concepts of 50 questions. Then once the exam is over, once the explanation is over, students after the class can go to the questions as well as given in the PDF. The 50 questions, the 50 explanation as well as 50 questions are given in the PDF itself. Once the total completion of explanation is done, students can open the question paper of questions, 50 questions, and take an OMR sheet if possible, or just write the correct answers without seeing the answers. So by this we will complete almost more than 600 questions. More than 600 questions in our this process. And whole, we are the schedule for the group 1. This lecture is important for as well as group 1 as well as the LAWCET exams or any other law entrance examinations. And most importantly, for any citizen of India, it is very important to know the constitution and the scheme of the constitution. So by this, I hope the students offline sitting in the class as well as the students online who are listening live or the recorded videos in the YouTube can please make sure that you have another phone or another device in which the question is, the answers are given, so that when I am reading the solutions, you have them in front of you. Or at least what you do, keep the soft copy in your hand and take a notebook in your hand, so that whenever I say which is important, you please note on the keywords. In exam, you don't have the time to read the whole. Once you understand the keywords, you can intelligently guess the answers. So we are going to deal with the constitution, governance and polity questions. Okay. Now please remember, we are not going in a very systematic way. We will be discussing the concept in a random way. First I will give you the heading or the concept we are discussing. Then I will explain you the concept. I will explaining you 50 concepts at a time. So most probably our lecture will be, if I explain you the concept in 1 minute, mostly our lecture will be of 50 minutes. Some concepts are very important which might go up to 3 minutes or 5 minutes also. So make sure that you have a notebook, soft copy in front of you, and you are noting down the important questions which I tell you, important concepts. So let us start. The very first concept we will be discussing is, please write down the keyword, the topic heading, judicial system, Indian judicial system. Now I will be, and if possible the LAWCET students and all the group 1 students, I always recommend you to keep a constitution copy in your hand. Such that you note down the article also. And if I make many mistakes, you are open to comment in the comment section. I will correct it then and there. So the very first topic which we will be dealing will be the Indian judicial system. Now in our constitution, the article which deals with the Supreme Court, the Union Judiciary or the Supreme Court, is article number 124. And article number 214 deals with the high courts. So this is very important. In your examination, directly the question will come. Supreme Court article is given under article number and it is a union judiciary. It is called as union judiciary. Union judiciary we call it as Supreme Court, and the state judiciary we call it as high courts. For the union judiciary, the concept starts with article number 124, and for the state judiciary, the state high courts, the concept starts with the 214. So please remember, as Supreme Court as 124 and the High Court as 214. I hope this is clear. The voice is clear and there is no disturbance. Next, now let us understand the Indian Constitution, the judicial system as per Indian Constitution. As we know that the Indian Constitution establishes a judicial system that is integrated as well as independent. So the very first concept which comes as Indian Constitution is Indian Constitution establishes our judicial system as integrated. Means though we have a Supreme Court, and under Supreme Court we have high courts, and under high courts we have subordinate courts. We have subordinate courts, or we have local courts. Though the arrangement is different, but we have only one. The whole system comes under one. That is known as integrated system, and as well as independent. What do you mean by independent system? The independent means in terms of financial things. In terms of financial. Now please remember how we can call Indian judiciary as independent. How? Because the salaries of the Supreme Court judges and High Court judges are charged on the consolidated fund of India. They are not open to the parliament to change or to reduce. Okay, so the parliament, the legislature cannot tinker with the judiciary salaries or the emoluments. So if the question comes, we can understand the integrated system. But if the question comes, how our judiciary is independent, the very first thing we can say that we have the salaries and emoluments of everything is charged on the consolidated fund of India. That means that the legislature cannot tinker or reduce the salaries against the judges, against the judiciary, and it makes sure that executive has minimum interference. Executive has zero or minimum interference in the working of the courts. And the third point, the very first point is the salaries of the judges of the Supreme Court and High Court are charged on the consolidated fund of India. Second, what is the second point I have told you? What did I discuss? The parliament cannot do anything or reduce the salaries against the judiciary or in negative aspect of the judiciary. Third thing, we have a system, we have a collegium system through which the judges appoint judges. Judges select judges, and the President of India appoints the Supreme Court judges as well as High Court judges. Please remember, this is a very, very important point. The President of India appoints all Supreme Court judges as well as High Court judges. Okay? Clear everyone? So let us discuss. The Supreme Court stands at the top of the integrated judicial system. Supreme Court, sometimes it is also called as apex court in the country. Apex meaning top court in the country. Below the Supreme Court, there are various high courts. Now, your homework will be, you have India yearbook. Now, I would advise you to please take India yearbook. Please take India yearbook, the latest one, and please open the chapter Indian Judiciary. Indian Judiciary. Judicial system. Judiciary rather. The Supreme Court stands at the top, and under Supreme Court there are various high courts. And under the High Court there is a hierarchy of subordinate courts. That is district courts and other lower courts. Okay? Now, this was about your judicial system as per the Constitution. Some more information about it. Now, I would advise all the aspirants who are giving UPSC exam or the UPSC exam or the judiciary and for general knowledge, please buy this book, India 2024. And in the chapter number 5, Law and Justice. There is a Law and Justice chapter in which all the basic knowledge which a person has to know, an Indian citizen has to know, is already given. Please purchase this. It is available on the. It is available offline as well as online. India 2024, the latest one. Okay. The page number is page number 87, chapter number 5, Law and Justice. Okay. So you can complete chapter 1 day. We have almost 40 days for our exam. We have almost at least 30 days for the exam. If we complete one chapter per day, we'll get a general knowledge. And at least 5 to 10 questions will be coming from the national syllabus, from the India Yahoo community. Because this is one of the sources which every citizen should know, basic knowledge. Now, as we understand that there is a Supreme Court, there are High Courts under the Supreme Court, and under the Supreme Court there are subordinate courts and other lower courts. Next, the single system of court. Now, what is the advantages of single system of court? What is the use? Now, the single system of court enforces both central laws as well as state laws. People might ask you, what is the advantage? What is the use of having a single system? If we have a single system, the advantage is that it can enforce both central laws as well as state laws. Unlike in USA. In USA, they follow the federal laws enforced by the federal judiciary and state laws enforced by the state judiciary. The advantage of in India having a single system of courts is that even the Supreme Court can enforce the state laws. Even the High Court can enforce the central laws. This is one of the advantages. It is very different from the US. Now please remember sources of the Constitution. The independence of judiciary has been taken from USA Constitution. This is a very basic question. The independence of judiciary has been taken from this source. The independence of judiciary has been taken from USA's Constitution. Right? Next. In India, the Supreme Court is the top court. Supreme Court is the top court. It is the highest court of appeal. It is the highest court of appeal. Supreme Court is the guarantor of the fundamental rights of the citizen. And last, it is also considered as a guardian of the Constitution. It is also considered as a guardian of the Constitution. Or it is Supreme Court is the guardian of the fundamental rights of the citizens. Fundamental rights of the citizens. There is a debate between who is the guardian of the Constitution. In one of the UPSC exam, the question was asked, who is the guardian? If we read it completely, the fundamental rights are protected by the Supreme Court and the Constitution is protected by the President of India. So, if we read the Constitution, the correct interpretation is the responsibility of saving the individual fundamental rights lies with the Supreme Court of India. Okay. So, by this, we complete our first concept, Indian Constitution and Judiciary. So, what are the points you have noted it down? First, the articles. Article number 124 for Supreme Court. Article number 214 for the High Courts. Then we have noted down financial independence. That is charged on the consolidated fund of India. The Parliament cannot decrease the salaries. Next. Supreme Court by a collegium system. They select the judges and President appoints them. The President appoints the Supreme Court judges as well as High Court judges. By this, it makes the independent judiciary. Next. Now I have explained you Indian judicial system is an integrated system. And what is the advantage of single integrated system, unlike which is US. So by this we complete our first point. Okay? Next. Now, nature of Indian Constitution. The second topic is nature of Indian Constitution. Now, Indian Constitution is a quasi-federal constitution. Indian Constitution is a quasi-federal constitution. The very most common question is Indian Constitution is federal or Indian constitution is unitary. Indian constitution is a federal constitution, or not truly federal, but it is a quasi-federal constitution. How we can say that? Now, whenever we say federal, now the word federal says there is a sharing of power. Federal का मतलब क्या है? There is a sharing of power. Sharing of power. जब भी आप power share होता, now there is a two levels of government. There is a two levels of government. In India we have three tiers of government. One is the central level, parliament, state level, the legislative assemblies, and the third level, the panchayats and the municipalities. So both the three have the constitutional status. Okay. So Indian constitution is a federal constitution, or you can say quasi-federal constitution, which means that there is a sharing of power. There is a sharing of responsibilities and sharing of powers. We have a dual polity. We have dual polity. How dual polity? There is a central government at center and at union and state government at the states. Okay. Now when you talk about the citizenship, India follows a single citizenship system. India follows a single citizenship system. India does not allow dual citizenship. Please be very clear. India does not allow dual citizenship. India follows only single citizenship. In countries like USA, there is a citizenship which belongs to a person if he is living in Pennsylvania and he has to take the citizenship or passport of Pennsylvania or the one of the state as well as the USA. So if he wants to travel from one state to another state, he has to take the visas. In India we don't have anything like that. We have a single citizenship. We can go from one state to another state without any interference. We need not take any visas. So in countries like USA they have a dual citizenship, but in India we have only single citizenship. So this was thing. Now in India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights. In India में irrespective of the state, if a person is born in Telangana, if a person is born in Andhra, if a person is born in Delhi, he enjoys, irrespective of the place of birth, he enjoys the same political and civil rights, and there is no discrimination made between them. So this was the concept of citizenship. The India follows a single citizenship system, whereas the USA follows dual citizenship. What is the advantage of being a single citizenship system? Each and everyone, irrespective of the place of birth in which the person is born, have the same political and civil rights. The same fundamental rights are available to both person born in Telangana or born in Delhi, born in North India or born in South India, irrespective of directions or locations. So by this we complete our second topic of our today's class. Third. Now let us look at the sources of the Constitution. Now when you look at the sources of the Constitution, people criticize some of the criticism of the Indian Constitution. Criticism, the very first criticism of the Indian Constitution is the people says that Indian Constitution is a borrowed Constitution. Indian Constitution is a borrowed Constitution. We have taken various concepts from the various countries. The critics say that India is a borrowed Constitution. The very first criticism. Second, a carbon copy of 1935. Now, when we see today's Constitution, we can say that 90% of our present day Constitution is of Government of India 1935. The first Prime Minister of India in 1935 commented that the Government of India Act 1935 is an act of slavery. Act of slavery. In 1935, when he was asked to comment on the Government of India 1935, the provisions which we will be discussing in the later classes, he commented that Government of India 1935, Government of India Act 1935 is an act of slavery. But after 15 years, when he became the first Prime Minister, he advocated the emulation of the Government of India in 1935. I will not say we have copied it, we have emulated. We got inspired by the structure of 1935 Act. Okay? So, it's an anti-Indian or un-Indian. It's an anti-Indian, un-Indian and un-Gandhian constitution. And un-Gandhian constitution. Gandhi did not say okay, we should borrow the concept from different countries. He said that the power center, the development centers should be the villages. If we understand the Gandhi's concept, idea of India, he said that Mahatma Gandhi always said that the development should start from the villages. Development should start from villages. But the constitution makers, they said the town, they selected the towns. So very few concepts, except in the DPSP, they included the Gandhian concept. And after 75 years, after almost 60 years, after almost, for example, 1950 we got the constitution enforced. In 1992, we got the panchayats and the 72nd amendment, 92, in the 92 and 1993, we have got the amendments giving constitutional status to panchayats and municipalities. It was nothing but Gandhian idea. First we said we discarded the Gandhian idea, but after 40-45 years we adopted it. So at the current constitution we cannot say that it is un-Gandhian. We have concepts of Gandhian. Then paradise for the lawyers. The whole constitution, the language in which written, unless until a lawyer is, the person has a knowledge of lawyer or he himself is a lawyer, cannot understand it fully. This is one of the criticisms. And the most common is the elephantine size. We have an elephantine size of the constitution. It is so bulky that it has central provisions, it has state provisions, it has the tier 3 provisions. So if you have all these provisions, it is very common that you will have a larger size. So it is called as elephantine. The elephantine words come from the elephant. It is very bulky. So these are the criticism of the Constitution of India. So by this we complete our third concept of the Constitution of India today's class. Now let us come to the fourth topic, schedules. How many schedules do we have? Originally, how many schedules do we have? When we say the Constitution of India, in 1950 we have 8 schedules. 1950 we have 8 schedules. Today we have 12 schedules. The most important schedules we will discuss. The most important schedules are 5th schedule. 5th schedule, what is 5th schedule? Let us see the 5th schedule. Provisions relating to the administration and control of scheduled areas and scheduled tribes. So what is 5th schedule? Provisions relating to the administration and control of scheduled areas and scheduled tribes. This is the 5th schedule of the Indian Constitution. 10th schedule. What is 10th schedule? Provisions. This 10th schedule is also known as anti-defection schedule. This 10th schedule is also known as anti-defection schedule, which was brought into the Constitution during the Rajiv Gandhi time. So 10th schedule discusses that provisions relating to disqualification of the members of parliament and state legislature on the grounds of defection. So what is the 5th schedule? Provisions relating to the administration and control of scheduled areas and scheduled tribes. 10th schedule, provisions relating to disqualification of the members of parliament and state legislature on the grounds of defection. Now 11th schedule. What is 11th schedule? Defection माने a person takes a party A ticket. A person takes a party A ticket. He contests the elections. And after winning, he shifts the party.
So it is happening.
It is happening. So to prevent that, this law was brought. But the way the political parties are gaming the system, this 10 schedule, the law has to be strengthened. They are bypassing it. If you say, if for example there is a member, there are 3 member party. If one person goes to other, he is disqualified. But if 2 goes, the party is not, the 2 are not disqualified. So there are very loopholes in the system, loopholes in the act, which has to be plugged.
The same thing happened with the ECI also.
No, this is only for the legislatures.
Previously, there was one Supreme Court judge.
Previously there was one person body, it was made multi-member body, again it was made one person. Again today, the current status of Election Commission of India is a multi-member body. The decisions are taken by majority.
But previously it was one
single member.
Opposition leader, present government leader, and Supreme Court judge. Now there are 2.
That is appointment of the chief election commission.
Appointment.
We are talking about the chief election. Now this 10th schedule is for anti-defection elements. Anti-defection.
If 2 members are going from the same party,
it is not considered as defection. But if one member goes, it will be considered as defection. And the anti-defection में जो drawback है, the speaker is the ultimate decision maker. Now due to the politics, the speaker just delays the decision, and it delays so much that the effectiveness finishes. So there is no time limit in it. The speaker should take a decision. So this is one of the drawback of both 10th schedule, anti-defection law. Now when you say 11th schedule, 11th schedule prescribes the powers, authority and responsibility of panchayats. Powers, authority and responsibilities of panchayats. Now it has 29 matters. The 11th schedule has 29 entries. This schedule was added by 73rd Amendment of 1992. 73rd Amendment of 1992 during the Narasimha Rao government. During the P.V. Narasimha Rao government. Added by the 73rd Amendment Act of 1992.
It was also the first of the South.
First Prime Minister from the
Non-speaking, non-Hindi speaking.
इससे पहले भी कर्नाटका से भी अजीत देवगौड़ा from Karnataka. So, P.V. Narasimha Rao from Telangana, from Andhra. From Andhra is the first Prime Minister who became the. So, this 73rd Amendment, 1992, the 11th schedule has 29 entries during the time of P.V. Narasimha Rao. And the 74th Amendment is the Panchayats. 12th schedule, powers, authorities and responsibilities of municipalities, the Nagarpalikas. They are called as Nagarpalikas. It has 18 matters. The amendment by which the 12th schedule was added was 74th Amendment of 1992. So please remember, 5th schedule is about administration, provisions related to administration and control of scheduled areas and scheduled tribes. 10th schedule, anti-defection law. 11th schedule, panchayats, 29 matters. 73rd Amendment, 1992. Municipalities, 12th schedule, municipalities, 18 matters, and 74th Amendment, 1992. 1992 is fixed. 73rd Amendment is panchayats. 74th Amendment is municipality. This is one of the most important questions.
One small note about 10th schedule. Since Supreme Court knows about this loophole, why the...
It is a policy decision. It is a policy decision. Supreme Court cannot order. As we see the organs of the government, the legislature, Supreme Court and executive are on the same level. It cannot order the legislature to do anything. It can only suggest something. But the discretion is of Parliament. Parliament is sovereign. As the Supreme Court is supreme, Parliament is sovereign. It can take. Now we have a very simple. In India, the elected cannot be less than selected. Supreme Court judges are selected people, but the legislators are elected. So how can a selected people give directions to the elected people? The legislature signifies the will of the collective will of the broader India. Collective will of the India. Supreme Court comes into action. As we discussed, it is the guardian of fundamental rights of the citizen. Supreme Court will come into action only when the fundamental rights are affected of the Indian citizen. Otherwise, it has very limited powers. It will not interfere in the policy decisions. Understood? So now, let us discuss about the fifth concept, the Indian Constitution. The Indian Constitution. The Indian Constitution is the longest written constitution of any sovereign nation in the world. Indian Constitution क्या है? Longest written constitution of any nation, of any sovereign nation in the world. The original text of the constitution was written and adopted in which year? 1949. What is the date in which we have a preamble? Preamble में कौन सी डेट है अपनी? 26 November 1949. 26 November 1949. On this day, we adopted and enacted our constitution. It was adopted and enacted our constitution. At that point of time, we had 395 articles, 22 parts and 8 schedules. So how many articles do we have? 395 articles, 22 parts and 8 schedules. Today, please remember, even in the material it is given as 470 articles. Even today we have 395 articles only. How come? You have the Constitution of India? Open it. And tell me, what is the last article? Originally we had 395 articles. Even today we have 395 articles only. So how many articles do we have? 395 articles. So please remember, originally we had 395 articles and even today we have 395 articles. But if you read amendments and sub-articles, the sub-articles brought by the amendments, it will be 470 articles. It will be 470 articles. So we don't know exactly the number. We can say 395 plus. We can say 395 plus, or we can say 450 plus articles. Originally we had 395 articles, even today we have 395 articles only. When we include the sub-articles brought by the amendments, subsequent amendments, then we can say that it has more than 395 articles. And how many parts do we have today? Originally it was 22 parts. Today we have 12 parts. Today we have 25 parts. Today we have 25 parts. Originally we had 8 schedules. Today we have 12 schedules. Understood this point? Now when we see how our constitution is scheduled, the constitution contains not only the fundamental principles of governance but also administrative provisions also. Administrative provisions also. How a government should run. It has given a detailed guidelines to even the central government as well as state government. The structural part is taken from Government of India Act 1935. The structural part of the present day constitution has been taken from Government of India Act 1930.
Basically, that 1935 Act was given by British.
Yes, it is not Britishers, but they did not. But they gave a name as Government of India Act 1935. What at all which was not suitable for us, we deleted it, and we have taken it. That's all. 90% you can say, more than 90% you can say. The whole structure is same. Understand? Understood? The structural part has been taken from Government of India Act 1935. Now when we read the constitution, we find a philosophical part as well as political. when we read the constitution, we find the structural part, philosophical part, as well as political part. When we see the philosophical part of the constitution, that is fundamental rights and DPSPs. Fundamental rights and DPSPs. Both the fundamental rights and DPSPs form the philosophical part of the Indian constitution. Right? Now when we say the fundamental rights has been taken from the USS Constitution Bill of Rights, we have emulated the Bill of Rights and given the name as fundamental rights. The directive principles of state policy, part 4 of the constitution, has been taken from the Irish constitution, from the Ireland. So the question might come, which is called as philosophical part of the constitution? The fundamental rights concept as well as the DPSPs. Combinedly, they are called as philosophical part. Okay? Now when we come to the political part of the constitution, the principle of cabinet government and the relation between executive and legislature drawn from the British constitution, has been drawn from the British constitution. So what is the political part of the constitution? The principle of cabinet government, that is the responsible government, where the prime minister along with the council of ministers aid and advise the president. And once the cabinet loses, the council loses the majority in the lower house of in Lok Sabha, then the government will fall. That is the political part, that is the cabinet, principle of cabinet government and the relation between executive and legislature has been drawn from the British constitution. So by this we understood that originally we had what is the original context of the constitution? Original structure of the constitution? We have the structural part is taken from Government of India Act 1935. Philosophical part is fundamental rights and DPSPs. The political part is the principles of cabinet government, that is relation between executive and legislature. Originally we had how many articles?
395.
How many articles we have today? 395. Originally we have how many schedules? 8 schedules. Today we have 12 schedules. Originally we have how many parts? 22 parts. Today if we include the amendment by sub articles also, it is called as, we have 470 plus articles. So this was your structure of Indian constitution. Now let us move on to the next concept, Constituent Assembly. Very, very important, very common question and the most repeated question. Constituent Assembly. Now, when we became independent, in 1946, after the World War II, the Britishers made a decision that India will be given the independence. But to give for the smooth transition of powers, there should be a Constitution of India. So, by the cabinet principle, by the cabinet commission, there was a decision to create a Constituent Assembly. When we talk about the Constituent Assembly, the idea of Constituent Assembly for India was first given by whom? It was given in 1934. Dr. B.R. Ambedkar was not in much picture. The very idea of the Constituent Assembly, as we are Indians के लिए Constitution होना, वो Constitution बनाने के लिए body group of individuals होना, that group of individuals is called as Constituent Assembly. Now this idea was given by whom? This idea was given by M.N. Roy. Way back in 1934.
So since the constitution was adopted from the British ideology, then why Dr. Ambedkar is given so much importance? Just because
he compiled it. The person, he was made the drafting committee chairman. He was the person to select which concept to be included and which is not. He with his advisor to the Constituent Assembly, legal advisor to the Constituent Assembly, B.N. Rao, both people, along with the other 7 members, selected the best provisions suited for Indian constitution, Indian polity, Indian society, and made a very progressive constitution. So he is considered as father of Indian constitution. He was the person who compiled it. He did not introduce new concept. He took the provisions from almost 11 countries and made sure that it is incorporated in the constitution. Ultimately,
He was inspired from.
he was inspired because he was not a normal person. He was highly educated. He was highly educated and he had PhDs in so many subjects. Economics, he has PhD in economics. He was PhD in law. So he was not a normal person. He was a, what you can say, he was a statesman. And he was not a member of Congress also, please remember. As though he was not a member of the Congress, the Nehru at that point of time gave the responsibility of drafting the constitution to a non-Congress person. He did not say that he is not a member of Congress, so he will not give the responsibility. He was staunch critic of Mahatma Gandhi and Nehru. But irrespective of the ideological differences, what was best for India is said. And we have our constitution today. The finesse, the ability by which he drafted the constitution, even we can see today. We have amended the constitution 105 times, but it was never suspended. So it is called as living document. So next. So the idea of the Constituent Assembly was given by whom? M.N. Roy. Way back in which year? 1934. In 1935, the Indian National Congress, for the first time, officially demanded a Constituent Assembly. So 1934 में idea आया by M.N. Roy. 1935 में पहली बार Indian National Congress demanded a Constituent Assembly to frame Indian Constitution. Jawaharlal Nehru, 1938, on behalf of Indian National Congress, declared that the Constitution of Free India must be framed without outside interference. Without outside interference. If the Constitution is for Indians, it has to be drafted by Indians only. And the Constituent Assembly elected based on adult franchise. The Nehru said the Constituent Assembly should be based on adult franchise by elections. But in reality, the Constituent Assembly members were not based on adult franchise. They were nominated people. They were nominated people. This is one of the criticism of Constituent Assembly. The demand was finally accepted by the British government in the August offer of 1940. 1940. So, if we see the timeline, the very first time idea of Constituent Assembly was put forwarded by whom? The idea of Constituent Assembly was put forwarded by whom? M.N. Roy. Which year? 1934. 1935, Indian National Congress demanded for Constituent Assembly. 1938, the Nehru at that point of time said that if it is for Indian Assembly, no outside interference. उसके बाद में the demand of the Constituent Assembly was accepted by the Britishers in which year? 1940 through August law. Please remember in 1940, Britishers was in the middle of the Second World War. They wanted the support from the Indian National Congress. So they said, okay. They said, okay, we'll accept, but only after the World War II. The World War II completed in 1945. So 1946 में एक कैबिनेट कमीशन बनी. कैबिनेट कमीशन के थ्रू कॉन्स्टिट्यूएंट असेंबली बनी. And we will discuss what was the Constituent Assembly के कितने members थे. Now please remember, Constituent Assembly was constituted before partition. First session of the Constituent Assembly was held on 9th December 1946. The first session of the Constituent Assembly was held on 9th December 1946. In total, there were 11 sessions of the Constituent Assembly. So how many sessions were there? 11 sessions. And the last session was held on 26 November 1949. 26 November 1949, where we adopted and enacted our constitution.
So in this all 11 sessions, the Muslim League was part of it?
No, in one session they said they will come, but they boycotted.
So they have different constitution.
They have the different constitution. They said they will come. If you see the 1946 cabinet, many people, who is the first Prime Minister of Pakistan? First Prime Minister of Pakistan. Jinnah was made Babe Pakistan, Mane, father of the Pakistan.
Okay.
Who was the first Prime Minister of Pakistan? Liaquat Ali Khan. He was a member of the 1946 the portfolios. He was a member of interim government, having one of the portfolios. So please remember, the cabinet, the Constituent Assembly was made before the partition, and even the Muslim League was part of it. But after the election which happened in 1946, the Jinnah gave a call for separate countryhood, nationhood. So they parted their ways. Okay. Next. So I hope the concept of Constituent Assembly, will discuss more about the Constituent Assembly in the next coming concepts.
Sir, is it correct that word secular was not there in triangle before?
Yes, originally we did not have the word secular and socialist and word integrity in our original constitution. The word secular, the spirit was secular. The spirit was secular.
It was just orally given.
It was orally. It was implicit. Now by the 42nd Amendment, 1940, during the Indira Gandhi time, by 42nd Amendment, 1976, Indira Gandhi government added the word secular, socialist and integrity in 1976, way after 26 years. And as it was challenged in the Supreme Court, the Supreme Court said that the amendment is right. Amendment is right. The Supreme Court commented that what was implicit, जो छुपे हुई चीज है, वो बाहर आ गई बस में. The spirit of the right to freedom of religion
was made on the basis of secularism.
Yes, it is said that what was implicit in the constitution was made explicit. That's all. And it upheld the constitutional validity of the adding of three words in the preamble: secular, socialist, secular, and word integrity. Remember this. Now let us see some of the. Now once the Constituent Assembly was made, therefore for doing of work, various committees were formed. We might get the question, match the following, or we will say that who headed which committee. For example, Union Powers Committee was headed by Jawaharlal Nehru. Union Constitution Committee was headed by Jawaharlal Nehru. States Committee was headed by Jawaharlal Nehru. Provincial Constitution Committee was headed by Sardar Vallabhbhai Patel. Please remember, the committees which are headed by Sardar Vallabhbhai Patel was Provincial Constitution Committee. Drafting Committee was headed by B.R. Ambedkar. Advisory Committee on Fundamental Rights, Minorities and Tribal Areas and Excluded Areas were headed by Sardar Patel. Please remember the committees which are headed by Sardar Patel are important, are very, very important. Now also remember Subcommittee on Fundamental Rights, which was headed by J.B. Kriplani. It is not given in the material, please write it down. Subcommittee on Fundamental Rights was headed by J.B. Kriplani. Main Advisory Committee on Fundamental Rights were headed by Sardar Patel. But Subcommittee on Fundamental Rights was headed by J.B. Kriplani. Was headed by this one of the UPSC question which came. The Subcommittee on the Fundamental Rights was headed by J.B. Kriplani. J.B. Kriplani. Rules of Procedure Committee was headed by Rajendra Prasad. The Rules of the Procedure Committee was headed by.
Do we still have this committee?
No, they were the ad hoc committees. Once the Constituent Assembly was formed, respective works were given. Once the Constituent Assembly is dissolved, we don't have these committees. They helped in forming the parliament. Once the Constituent Assembly is finished, these committees are also dissolved. These are the ad hoc committees. They are called as ad hoc committees. We don't have any committees today of that time. Steering committee was headed by Rajendra Prasad. So, Rajendra Prasad is the first permanent chairman of the Constituent Assembly. He also became the first president of India also. Independent India. So rules of procedure committee was headed by Rajendra Prasad and steering committee was headed by Rajendra Prasad. Now let us discuss more about the fifth schedule. Let us discuss more about the fifth schedule. The fifth schedule of the Indian Constitution deals with the provisions. We have already discussed this. Deals with the provisions of the administration and scheduled areas and scheduled tribes residing in any state. Please remember, it is very important. The fifth schedule of the Indian Constitution deals with the provisions relating to the administration and control of scheduled areas and scheduled tribes residing in any state except Tripura, Assam, Meghalaya and Mizoram. Sixth schedule is there. In which the provisions for these four states are given. But the provisions given under the fifth schedule are applicable to whole India except
These four states.
Tripura, Assam, Meghalaya and Mizoram. You have to exclude, whenever you talk about fifth schedule, scheduled areas and scheduled tribes, you have to exclude Tripura, Assam, Meghalaya and Mizoram.
Reason for exclusion?
They are the specific states. They have been given special importance. A separate schedule has been given for them. The sixth schedule talks about these four states. If you talk about fifth schedule, you do not include Tripura, Assam, Meghalaya and Mizoram. Because sixth schedule has been allotted the tribal areas of these four states.
Just because of their culture.
Just because they have a very distinct culture. To honor their distinct culture, to respect their distinct culture, a separate schedule has been formed. An area designated under the fifth schedule implies that all land within the scheduled area is assumed to be Adivasi land. Fifth schedule में जो भी areas है, they will be called as tribal land.
Scheduled areas में जो है.
Scheduled areas में, for example, तेलंगाना है. तेलंगाना area में this Afzal Nagar it comes under the fifth schedule. Now this area will called as Adivasi land.
Even government cannot interfere in that.
There are very strict provisions, and if you want to enter, you have to take the permission of these people, local people. So special protection has been given. So whatever the areas included in the fifth schedule will called as Adivasi land. Called as Adivasi, assumed to be Adivasi land, that is tribal lands. Consequently, not only should no land be transferred to non-Adivasis. The problem is whenever there is a selling of land, there is sale of land. An Adivasi land has to be given to Adivasi only. You cannot give the land to non-Adivasi. But any land currently owned by non-tribal individuals, if transferred, should revert to the scheduled tribe. Agar non-Adivasi people is the owner of the, if he wants to sell, it has to be reverted back to the tribal people. He cannot sell it to non-tribal. If it is a tribal, the extent should be in between Adivasi only, tribal people only. The governor has the authority to create regulations that either prohibit the limit of transfer of land from tribal individuals to non-tribal individuals. So who has the ultimate power to govern this? Governor. Governor has been given the power to regulations, to issue any orders. Okay, so this is the fifth schedule. Fifth schedule do not include four states. What are the four states? Tripura, Assam, Meghalaya and Mizoram. Okay. So let us understand the next concept. Very important case law. Very important case law. Keshav Nanda Bharati case 1973. Keshav Nanda Bharati case 1973. The Supreme Court held that. Now when we say there was a question. Does the preamble is a part of the constitution or not? Is the preamble constitution? Now this question went on to the Supreme Court. Supreme Court in Keshav Nanda Bharati case held that preamble is a part of the constitution. Keshav Nanda Bharati case held that preamble is a part of the constitution.
Previously it was not considered.
Previously, in the Berubari case, Supreme Court said the same question as preamble is not part of the Constitution. Remember, there are two case laws which are very, very important when it comes to the preamble. 1960 Berubari case. 1960 Berubari case, Supreme Court said that preamble is not part of the Constitution. But after 13 years, Supreme Court reversed its stand and said that preamble is part of the Constitution. That is Keshavananda Bharati case. That is the Keshavananda Bharati case. And there was another case, LIC case, which happened to be in 1995. Which happened to be in 1995. The Supreme Court said that preamble is not only the part of the Constitution but is an integral part of the Constitution. Integral part of the Constitution. First, in 1960, Supreme Court said preamble is not part of the Constitution in the Berubari case. 1973, Keshavananda Bharati case, the Supreme Court said that preamble is part of the Constitution. In 1995, LIC case, Supreme Court said it is an integral part of the Constitution. Understood? Now please remember preamble. Preamble original was called as objective resolution. Please note it down. Preamble originally was called as objective resolution, which was moved by Pandit Nehru and passed by Constituent Assembly. Please note it down. Preamble originally is called as objective resolution, which was moved by Pandit Nehru, and which was passed by Constituent Assembly. Which was passed by Constituent Assembly. Which was passed by Constituent
Objective
Resolution. Original name of the preamble was Objective Resolution. Okay? Preamble is known as Objective Resolution, which was moved by Pandit Nehru and passed by Constituent Assembly. Now let us discuss the objectives of the Constitution. Objectives of the preamble. The word justice, liberty, equality and fraternity are called as objectives of the Constitution. Yes, 10th. The words, now when we read the preamble, we get these words: justice, liberty, equality and fraternity. These four words are called as objectives of the Constitution. And when we see the objectives of the Constitution, we have ideals also. The ideals of the Constitution are sovereign, socialist, secular, democratic, republic. The ideals of the Constitution are sovereign, socialist, secular, democratic, republic. The ideals of the Constitution are sovereign, socialist, secular, democratic, republic. Objectives of our preamble or the Constitution is justice, liberty, equality and fraternity. So by this we complete the 10 concepts. Now we'll take a break of 5 minutes and then we'll continue.